about the sheriff. Good idea should not get too deep. Oh no, oh.
Welcome back to the PI show. Before the break we were discussing juries and the role of juries in civil trials in Victoria. And I think it's fascinating to see a jury trial in operation, but it's quite different to American TV shows.
Yes.
Where the barristers in Victoria aren't allowed to leave the bench,
The bar table.
the bar table, and address juries.
Yes.
So
A bit different to the O.J. Simpson trial and the other TV shows we've seen in America, where they're walking around right up in front of the jury box, etc., and going through normal television shenanigans. It doesn't quite happen that way, and in fact it's interesting that in Victoria the courts are open courts. There are jury trials each day, and if people want to go in, as you say, and sit in the public gallery, they can actually see a trial in operation.
Yep. And the barristers are at the bar table,
Yes.
and then they address the jury, and there's a skill in addressing a jury as well.
Yes.
And some barristers, I think, are more flamboyant than others, and some barristers, are less flamboyant, if you like.
That's why you generally try and pick people that can engage a jury, Harry, so that they actually don't lose them. They actually get them involved. They listen to the case and listen to the facts, and yeah, no, there is a skill. It's an art form.
There's a great, there's great storytelling. They can tell a jury a story. They can, as you say, engage them. They can be believed, and they can take the jury through the facts and the evidence.
And they've got to sort of communicate in an effective way to a jury, where you can't be too complicated about the law, and you've got to try and, I think, explain to jury the facts and the story and the circumstances surrounding the facts, and appeal to, I think, ultimately jurors' common sense.
Correct.
And I think the judge in the juror's handbook quite rightly says the jury should make up its mind at the end of a trial.
The end of the evidence, that's right.
Because sometimes you hear some matters which are damning for a plaintiff, but ultimately they're put into a context.
Correct.
And ultimately they're corrected, or so sometimes when I've sat in trials, you've had your highs and lows for the day, and at the end it's a balancing exercise.
Correct.
So, is it a flip of the coin, Tony? Or is it the scales of justice?
Well, I mean, after so many years of practice, I'm still nervous when I'm waiting for a jury decision, whereas I'm not as nervous with a judge, because juries can be a bit more unpredictable. So it is a bit, yeah, it can be a flip of a coin at times. I mean, there's been occasions when you expect a certain result and you don't get it, and vice versa. So yeah, there's a bit of that in it.
But the actual verdict is very short. The foreman comes back and answers the questions that have been posed by the judge. Was the defendant negligent? Was the plaintiff contributory negligent? And how much is the claim worth?
That's correct.
In effect, three questions. So it is a nervous time. But,
yeah.
And once a jury's given a verdict, the judge, what happens then?
The judge thanks them for their time and discharges the jury. Sometimes, if it's been a complicated or lengthy trial, he will excuse them from jury duty for a couple of years. That's the discretion.
And then the jury's discharged, and in Victoria you can't then talk about your experience in the jury room.
That's correct.
So you can't talk about what happened, the decision that was made, because there was a case, I think in the 80s, where a juror did talk on radio about a court case, and they changed the...
Well, more importantly, they shouldn't be discussing the case whilst it's running.
As well.
Because they can be seriously influenced by outside factors.
They're not allowed to. The judge explains that.
Yep.
That's all we've got time for juries. We've had a number of questions through the website from viewers, which is very, very encouraging. Tony's got a couple of questions. Some of them, I think, relate to rehabilitation, which we were discussing last week.
Yes.
Seems to be a big issue, rehab, Harry. This is a fellow who had an accident 5 years ago. He injured his neck, back, and had surgery on his shoulder as well. And after being off work for some time, he was encouraged back to work, albeit he says he wasn't ready. He says that he went back to work and his job was terminated, and his wife was then retrenched. They've lost a house and a car. He says, what rights do I still have now, seeing that he's gone back to work full-time employment, alternative employment, and he says the doctor's going to close his case. What are his rights?
I'm not 100% sure what he means by closing the case. Often the insurer, if they don't hear from someone over a number of years, they've had an injury, they've gone back to work, they've got a clearance from their doctor, and the case, in effect, is closed. The same with TAC. Yes. They don't hear from someone for 5 years, and after 5 years, something happens, and the injured person says, "Look, my injuries haven't gone away."
Yes.
What does TAC or work cover do?
Well, he's still entitled to his medication and that, isn't he?
I believe he's entitled to his medication. I believe he's fair and reasonable medical expenses as long as they relate to the incident or the accident that occurred. If, for example, you said his shoulder had ongoing problems, if it required an operation 6 or 7 years after it, if that was connected to the original incident, the doctor has to connect it. Medically, they have to connect it, and his entitlements continue.
And plus, you would have thought that even if he's gone back to full-time alternative employment, he's got some prospects at getting pain and suffering certificates if it's a work cover case.
Yes.
But let's say his employment sort of ceases, he can't go back to work. He's tried for 5 years and he's collapsed at the end of 5 years. He's still entitled to weekly payments and still medical expenses. The only issue in my experience is that the insurers are often suspicious that something else has happened to this person. If they haven't heard from them or had any claim or medical expense claim for a number of years, the insurer becomes suspicious that they might have fallen on their shoulder on a weekend or in some leisure time activity. And I think the onus comes back onto the worker. You prove to me, the insurer, that you've still got injuries arising that are 5 years old.
Of significance, this fellow's still on painkillers, so someone's got to be paying for him.
But if they were paid for by the insurer, that's fine. But if he pays for them himself and the insurer just hasn't heard from him for 5 years, in my experience, the insurer becomes suspicious. Why is this person now claiming?
Connected to the claim, you're right.
Yeah, so that's my only right. So, and the onus often goes back onto the worker. You prove to me that your claim still arises from that original injury.
But in short, he's still got rights, he's still got entitlements, to statutory benefits and also possibly common law damages.
Yes.
If in doubt, seek advice from a lawyer.
Precisely.
Yeah.
That's the category, isn't it?
I think that's all we've got time for this week. There are a number of other questions. We'll probably deal with them in future shows. So if viewers can keep making inquiries onto our website, that is very, very helpful feedback. We enjoy personal injuries, and we encourage people to send their queries into our website. That's all we've got time for today. Both of you are older and wiser again after another week.
Thanks, Harry. Thanks, Marty.
Thank you.
Thanks, viewers.